All right. Hey, everybody. This is John Massengill and Caroline Hines, and we are the program coordinators for the South Carolina ESSER subgrant. Thank you for joining this short webinar on updated equitable services as of October 2020. And a disclaimer, this presentation is designed to help you understand federal and state requirements related to equitable services for the ESSER subaward. This presentation is not a substitute for reading the ESSER Subgrant Award, the program-specific assurances, the SCDE's assurances and terms and conditions for federal subawards, and the applicable federal regulations for this subaward. The purpose of this session is to provide updated information about the CARES Act and specifically the funds provided by it under the ESSER Fund, and the requirements for equitable services to students and teachers in participating nonprofit, non-public schools as of October 2020. So the proportionate share calculation, section 18005 of the CARES Act provides for equitable services. This applies to both the ESSER and GEER funds. Equitable services should be provided to students and teachers in non-public, nonprofit schools in the same manner as provided under Section 1117 of the ESEA. The LEA must maintain control of the funds provided for equitable services at all times, and a nonprofit private school is defined as a non-public elementary and secondary school that is A, accredited, licensed, or otherwise operates in accordance with state law, and B, was in existence prior to the date of the qualifying emergency for which grants are awarded under this section. And this is the manner in which the ESEA instructs LEAs to provide equitable services. So to the extent consistent with the number of eligible children identified under Section 1115C, in the school district served by a local educational agency who are enrolled in private elementary schools and secondary schools, the LEAs should provide services on an equitable basis. And then moving on to a timeline of the CARES Act. The CARES Act was passed on March 27th of 2020. Then on April 30th, the U.S. Department of Education issued initial guidance as to how equitable services will be provided under the CARES Act. This guidance said that private schools are entitled to funding in the same way public schools are, regardless of low income status. Then on July 1st, 2020, the department issued an interim final ruling which said that which gave an option that LEAs could provide equitable services based on the Title I calculation, but they would also have to spend their own allocations solely on Title I students as well. Then on August 21st and 26th, preliminary injunction orders were issued. And then on September 4th, 2020, a summary judgment order was issued in NAACP versus DeVos, which struck down the interim final ruling from July 1st. At this point, the U.S. Department of Education has 60 days from September 4th, which would be November 3rd, 2020, to appeal the summary judgment, but they have sent a letter indicating that they do not intend to pursue an appeal. This letter is linked under the Equitable Services section of the SCDE ESSER webpage. Then moving on to what the summary judgment order said in NAACP versus DeVos. The judge ruled that in the interim final rule promulgated in July 2020, the U.S. Department of Education incorrectly construed the CARES Act to require LEAs to treat all private schools as entitled to equal funding as public schools, regardless of their low-income student populations. Judge Friedrich held that the interim final rule is contrary to the unambiguous mandate of the CARES Act. She ruled that Congress intended for funding to follow the Title I allocation, including inequitable services. She said there is no ambiguity in the language "in the same manner as," and she also ruled that the U.S. Department of Education lacks the ability to regulate on these CARES Act issues. And then the U.S. Department of Education they responded to the ruling on September 9th, and they said on July 1st, 2020, the U.S. Department of Education published an interim final rule regarding equitable services under the CARES Act. On September 4th, 2020, in NAACP versus DeVos, the U.S. District Court for the District of Columbia issued an opinion and an order vacating the interim final ruling. Accordingly, the interim final ruling is no longer in effect. And I will turn it over to Caroline.
Thank you, John. Many of you may be wondering what the next steps are for districts following this new ruling. Districts have several options depending on where they are in the consultation process. For districts who have determined and expended their proportionate share based on enrollment and have expended all funds, no other action is required at this time. Districts may not recoup goods or services provided accepting assets that are inventoried. An example of this would be laptops. Examples of a good or service ineligible for recall would include expendable items such as masks or hand sanitizer. For districts who have determined but have not yet expended all of the proportionate share based on enrollment, may elect to reconvene and adjust proportionate share based on Title I status. If during the adjustment the district determines it has met the equitable services obligation by reaching or exceeding the proportionate share, no other action is required. If after the adjustment the district determines the proportionate share has not been met, the district should re-engage in a meaningful consultation with participating private schools to determine how remaining funds will be used. Please note there is newly added guidance on the ESSER webpage concerning Title I calculation under the Equitable Services section. For districts that have not yet determined the proportionate share, they should now determine the proportionate share based on the methodology outlined in Section 1117 of ESEA. For districts who have determined and expended the proportionate share based on Title I status, no additional action is required with respect to the equitable services provision. This is provided that all eligible students in private schools were included in the calculation methodology. Districts that determined proportionate share based on Title I status are no longer obligated to expend ESSER funds solely on Title I schools. Therefore, districts should consider whether or not it needs to revise its ESSER budget and submit an ESSER spending plan amendment. Now we will be moving on to some frequently asked questions. What if my district has purchase orders currently being processed or completed for private schools? If a purchase order has already been completed and is an allowable expense under the allowable activities, it may count towards the allocation the non-public school receives, even if it exceeds the allocation under the new calculation. It is allowable to freeze or cancel purchase orders until additional consultation can occur. However, LEAs must reconsult with non-public schools and allow them to decide whether the school wants to cancel, freeze, or adjust the order. Does this mean my district does not need to provide equitable services anymore? No, this rule does not mean districts are no longer required to provide equitable services. This means that districts will be able to change how the equitable services are distributed. What if my district has recalculated and all of the eligible private schools have received allocations that equal or exceed the new calculation under Title I? No additional services will need to be provided. Can my district keep its current allocation even if it exceeds the Title I allocation calculation? The current interim final rule regarding this would not allow it. However, if an LEA documents that it was following previous guidance from the U.S. Department of Education, then it may be allowable. An LEA should still reconvene and reconsult with non-public schools and document all dialogue between parties. Some reminders. Anytime an LEA chooses to change how equitable services are to be allocated, you must reconsult the non-public schools eligible for participation. Consultation must be meaningful and timely. Districts who re-engage in meaningful consultation should submit a new non-public school consultation form. No funds may go directly to a private school. And again, document all dialogue and interaction between LEA and non-public school. Any disputes between LEAs and non-public schools about equitable services will be facilitated by Teresa Gregory. If you have questions following this webinar, please feel free to email the SC ESSER email or contact me or John Massengill through email, which are listed below. Thank you for watching.